So my name is Nicky Beechey. I'm Chief Advisor in the Advocacy team in Wellington, and the purpose of my presentation today is, in a very practical sense, to take you through the main points of change to the disclosure regime. And as mentioned by Ben, the new disclosure rules are adding to the existing rules, and I think all cases that there is no obligations being taken away or replaced. And leading up to these changes, the general view has been that the current disclosure requirements have not been effective in providing consumers with good, easy access to key information about their loans before they enter into those loans. Most lenders, we know, comply with the Act's current disclosure requirements, but we also know that many borrowers, particularly those using second and third tier lenders, do not really understand the true costs of their loans, or indeed many of the key terms of their loans. So in short, the new rules that I'll take you through basically requiring earlier and better disclosure of information to borrowers at the outset of the loan, and that is consistent with the newly prioritised consumer protection purpose of the legislation. And the new regime also brings a range of enhancements to information that's provided to borrowers during the lifetime of their loans. So I'm just going to cover today the timing of initial disclosure, the new information that needs to be disclosed, publication of the cost of borrowing and standard form contract terms, changes to variation disclosure, both agreed changes and unilateral changes, and changes to transfer request and continuing disclosure, including the limit of repayment warnings on credit cards, and changes, I've just got a few slides on the changes to default interest to finish up with. So, starting with timing of initial disclosure, this is a really important one, obviously. Under the new Act, the lender must now disclose all terms of the contract to all borrowers and guarantors before the contract is entered into. And this obviously contrasts with the current situation, which is that must be disclosed within 5 days. And the second point is that where credit-related insurance is involved, or where the consumer credit contract includes a repayment waiver or extended warranty, the lender must supply the borrower with a copy of the terms of that insurance, waiver or warranty before the borrower enters into that contract. And the point of this change, obviously, is to ensure that all borrowers and guarantors are, as much as they can be, and fully informed on the terms and conditions of the contract before it's entered into. In addition, there is some new information that lenders must disclose at initial disclosure point. And just going through these briefly, your trading name, if it's different from your legal name, as well as your full legal name. The name under which you're registered on the Register of Financial Service Providers and your registration number. The name and contact details of your dispute resolution scheme, unless of course you're not required to be a member of such a scheme. You must also provide a statement about the borrower's right to apply for hardship and how to go about making that application. And the final point, which isn't on the slide, which is that if you use a disabling device on secured consumer goods, you'll need to provide a clear description of how the device functions, when it might be activated, and how the borrower can obtain use of those goods in an emergency. So, standing disclosure, these are two important new lender responsibilities to improve transparency for borrowers, which then, as Ben talked about, enables consumers to shop around, compare rates, interest rates, and promote competition in the market. So the first of these two important provisions is to make sure that your standard form contract terms, if you are using standard form contracts, are publicly available. Now this can be done in several different ways. If you have an internet site, then you have to display your terms prominently and clearly on your website. Also, if your business premises are accessible to the public, you must display a notice, which is prominent and clear, that states that a copy of the terms are available on request free of charge. Then, of course, if you receive such a request, you must immediately supply that information free of charge. The second new responsibility is that you must publicise the cost of borrowing. So you have to publish all costs of borrowing for each class of contract that you're offering, which obviously includes credit fees, default fees, annual rates of interest, and default interest rate charges. Again, this can be done on your internet site, or if your business is available to the public, to display a notice which must be prominent and clear that these costs are available on request free of charge. So disclosing agreed variations, the general rule here is that a lender must disclose to the borrower the full details of any change to the contract before the change takes effect, and that is still the general rule, that still remains. But under the current Act, where agreed changes reduce the borrower's obligations, there were some exemptions for disclosure purposes. And so the change to the legislation is that those exemptions have now been removed. Lenders must now make disclosure of all changes, even where those changes reduce the borrower's obligations, such as would be the case where the time for payment is being extended or a security interest is being released. The lender can choose to make this disclosure in one of two ways, either by providing disclosure within 5 working days of the change taking effect, or with the next continuing disclosure statement. It's a similar story with the disclosure of agreed variations. Oh, sorry, just one more slide, which is about increase to in credit limit. This is a new requirement that if there is an increase to any credit limit, that must be disclosed, and again it must be disclosed within 5 days or at the same time as the next continuing disclosure statement. Then with unilateral changes, the general rule remains, again, the lender must disclose all these kinds of changes, but the new legislation states that some exemptions have been removed. Disclosure will not now be required. Sorry, got that wrong. As with disclosure of agreed changes, some exemptions have been removed, and disclosure will now be required in all circumstances. As with the process for agreed changes, the lender can do this in 2 different ways, either within 5 days of the change taking effect, or at the same time as the lender provides the borrower with the next continuing disclosure statement.
Are those days working days?
Yes, now there's one pointing out where it's not working days, but I think, which is in one of the reposition versions, isn't it, Susan? But all the other days are all working days. Yep. So just a note here that changes to the amount of an interest rate or the amount of any fee may still be, disclosure of that may still be made by publication at the lender's place of business or on its website and in daily newspapers in the areas where the lender carries on business. So moving now to disclosure of transfer rights. The new Section 26A will impose an obligation on lenders to inform borrowers and guarantors if they transfer their rights to another lender. Lenders must now disclose within 10 working days of the date of the effective transfer date. And the things that must be disclosed are the name, address, and contact details of the new lender, the new lender's financial service provider registration number and dispute resolution scheme, the date of the transfer, and the impact on the borrower, if any. And just a note here that disclosure is not required if the transfer is merely for securitisation or covered bond arrangements. Continuing disclosure. So under the existing Act, many lenders do not need to provide continuing disclosure to borrowers if the contract requires payments in accordance with a set schedule. Now this exemption has now been removed. This only applies to new contracts that are entered into after the 6th of June. So lenders, for those new contracts after 6th of June, lenders will need to issue continuing disclosure statements to borrowers every 6 months or every 45 working days in the case of revolving credit contracts, unless their situation falls under one of the remaining exemptions. And those exceptions are now if the lender maintains a website allowing the borrower access to relevant information for any reasonable period, and the borrower has consented to the information being provided in that way. So obviously if there's a website, information being able to be accessed, or where neither interest charges nor credit fees are payable. Now, special case here is that there is going to be a minimum requirement for a minimum repayment warning on credit cards. Now this applies to both new and existing credit cards as at the 6th of June. From the 6th of June, there will need to be a warning set out, and the form of that warning has been set out by regulation recently. If you only make the minimum payment each month, you will pay more interest and it will take you longer to pay off your balance, and then invites borrowers to visit Sorted to calculate how you can pay off your credit card balance faster and pay less in interest. So that warning must be presented reasonably close to the amount stated as the minimum payment for each payment period, and the format, font and font size of the minimum repayment warning must be easily readable. And there is some exceptions here where no warning is required, and that is where the closing, 3 exceptions, where the closing unpaid balance of the credit card is under $100, or where an interest-free period applies to the closing unpaid balance, or where there's a payment arrangement between the lender and borrower, which has effectively replaced the minimum payment that would otherwise be required. So moving on to request disclosure. The Act provides for a borrower to request disclosure on a range of matters, as set out in section 24.2, and those request disclosure provisions have been broadened. From the 6th of June this year, a borrower or guarantor can now request a continuing disclosure statement. So that is both for loans. So they can now request it from the 6th of June, but it applies to loans that are pre-existing as at 6th of June. So if a borrower requests that continuing disclosure statement, then it has to be supplied from the 6th of June, but it doesn't apply. We've had a little bit of confusion because it doesn't apply to the continuing disclosure we talked about in the previous slide. I'll clarify that a little bit later. So a borrower or guarantor can also request a copy of the contract between the borrower and the lender. Now, if the disclosure rules are not followed, there are 2 main consequences. A lender cannot enforce the contract until correct disclosure is made. That means that the lender can't recover interest fees or other charges or require repayment of the loan amount until correct disclosure is made. Borrower can also cancel the contract at any time, but depending on the contract may have to pay establishment or cancellation fees and ordinary interest. Also, we just note here that it may be an offence against Section 13I of the Fair Trading Act if a lender misrepresents its right to enforce a contract where it has not made correct disclosure. And that, of course, is liable to a penalty of up to $600,000 under the Fair Trading Act. So I'll just finish up with a couple of slides on changes to default interest. So as you know, there are no changes to the rules for ordinary interest. Parliament did discuss whether or not to introduce interest rate caps, but decided not to. So there is no limit on interest that a lender can charge, other than the general rule that contracts should not be oppressive. However, default or penalty interest has been a key cause of debt problems for borrowers, particularly those who have high interest rate loans. Borrowers can quickly find their debt spirals out of control because of default interest, and this is because under the existing law, lenders can charge default interest on the whole of the outstanding balance following default. So to deal with this problem for borrowers, which can have quite serious consequences, Parliament has decided that the law relating to default interest will change, and default interest will now only be able to be applied to the amount in default and not the whole balance of the loan. So I'll just give you a little example to show what this means, which is that if a borrower has $5,000 outstanding on a loan and misses a payment of $100, this is just a simplified example. Currently, the default interest can be charged on the $100 missed payment, and then if the contract includes a call-up provision, then default interest can be charged on the whole amount to be payable with the rest of the $5,000. So under this new law, the default interest is only payable on the amount that's actually in default. And then the remainder of the loan can't be called up, and then it can be called up, but it can't have default interest applied to it.